let's think about some issues that we'll start with leases. We've already mentioned those. Think about some issues that may arise both in the contract and in the negotiation of that contract. When can you negotiate a contract? Think about all the times that you visit a website and you have to accept the terms of use in order to proceed to the website. When you click that accept button, you are agreeing to a contract that you will comply, that you agree to the terms of use for that website. Do you have any opportunity to negotiate that contract? Heck no. The arrangement is either you accept this contract by clicking I accept and proceeding to the website, or you reject it wholesale by refusing to accept and closing out your browser or visiting a different page. So that's a circumstance where you have zero bargaining power. Think of it as a balance of power. You've got a scale, and maybe you have some power, maybe you don't. In the case of that, I don't have any power in those contracts either. If I want to visit the website, I have to agree to the terms of use. By contrast, when you're looking at a lease agreement, depending on the power dynamics, depending on how in demand that space is, depending on how long it's been vacant, depending on, various influences, you may actually have some bargaining power. So keep that in mind. When you do have the opportunity to negotiate a contract, there's a lot that you can do, but you can only do it if you've thought through what you want. So ask yourself, before you go in to negotiate a contract, ask yourself a series of questions. I have a handout that you all are gonna receive in connection with this presentation that is sort of my pre-negotiations tool. And it identifies who are the parties, what am I looking to get out of this contract, and there's lots of room for notes and expectations on the back. I recommend you fill that out before you even go talk to a potential leasing agent or landlord. Because if you don't know in advance what you want, how are you going to know if you've gotten it? Give some thought to that. It's how I negotiate contracts. Before I ever go talk to opposing counsel about settling a case, for example, I know exactly what I'm looking for. Same thing if I go negotiate a contract with a union. I know what I'm going in hoping to negotiate in advance. So use that handout. Think about who are the parties to the contract. How long do I want this contract to last? If it's a lease, do I want maybe 6 months or a year because I need flexibility given my brand new business, or do I want 5 years so that I can lock in a really good rate? Consider that. When do you want it? Do you want to start your lease tomorrow? Do you want to start your lease next year? Be aware of that in advance. Where do you want it? And what if? The key phrase is what if. What happens if everything goes sideways? You don't enter a contract to memorialize how great everything is going to be. I think I already mentioned that. So next, before you even talk to the other party, for example, in a leasing agreement where you have some bargaining power, do some Google research. Look at the relevant laws, or in the alternative, if you have an attorney on retainer, sit down and meet with your attorney to see if there's anything you should know before entering negotiations. And third, prepare any facts, figures, or documents that you may need to back up your negotiation points. So remember, negotiations will be much smoother and much more productive for you if you are trustworthy and communicative with the other party. So I know there's sometimes like an impulse to hide the ball. And to some extent, you don't want to walk in and say, this is the most I'll pay for this space, and I really want it. But at the same time, you don't want to act like you don't want the space. You wouldn't be at the table if you didn't want the space. So keep that in mind. Let's take a quick look at some of the issues that can arise with other types of contracts. I'm not going to spend a lot of time talking about consignment contracts because I don't think they're that broadly applicable, but this is a good example for thinking about how things could go wrong. So you enter a consignment agreement, and it's something like, if and when this sells for X amount of money, then we will give you Y portion of that X amount of money. But what happens if an item doesn't sell? What happens if an item is stolen from the shop or was stolen by the consignor? What happens if it turns out an item is fake? This is the kind of thing that you want to think through. What happens if everything goes wrong? This is why nobody likes to invite me to parties. All right. With that, let's consider vendor contracts as another example, because I know this is a type of contract that is going to be very common to a lot of your businesses. Think about things like the length of credit terms, any volume discounts you might be seeking, price locking. What happens if there's a defect? Oops, oh no, I'm on the right slide. Do you have to return the defective product? Who pays for the shipping on that return? What constitutes a defective product? How perfect does a product have to be when it gets to you? Do you want to have an option to cancel the vendor relationship or vendor contract? Do you want the vendor to have the option to cancel the arrangement? And should either party or both parties be required to provide notice of perhaps 30 days before cancellation? Might be a good idea. How about this? Can you commit to a long-term vendor contract at this stage in your business? If not, that's something you should know going into the contract negotiation. Think about what you want and think about what the vendor will want and try to find the middle ground. This is not rocket science. So for example, if you're talking about a vendor of toys and it turns out those toys are covered in lead paint, what's going to happen? Shipments arrive untimely or damaged. These are the kinds of things that you can have a contract in order to reduce that big worry. All right. I have one final and absolutely critical point to make to you all. Use language you can understand in your contracts. By the way, this phrase that you saw on your screen, that's actually Taiwanese for "this person will pay for everything." If you didn't understand that and you put that in your contract, then you could be in real trouble when it comes time to litigate contract issues. So if you don't speak the language, let's say somebody hands you a lease agreement and you don't understand it because it's written in a lot of legalese, consider paying an attorney to help you get better language that's going to be more beneficial to your business. At your stage, also consider reaching out to the Hispanic Business Center with help just figuring out what the heck the contract language means. You don't have to be an attorney to know a little bit about general contract clauses and the like. Okay? Seek help, seek resources. Doesn't necessarily have to be a paid attorney. All right, so best practices: know what you want in advance. Write it down in advance, use words you understand, and don't sign anything unless, number one, you have read it, and number two, you agree with it. If you disagree with it and you sign it, you will still be bound to those terms under the law. So keep that in mind. And with that, we're going to talk about employment law. But for some reason, don't ask me why I've structured this presentation this way. I guess because I want you to understand that this is a huge field and we only have a tiny bit of time to discuss it. Actually, you know what? Before we jump into employment law, I'm going to check the chat and see if you guys have any questions about contracts that I should answer now. So bear with me. Oh my goodness, you guys are so quiet in the chat. I want you to know that you should feel 100% free to type in any questions you have in the chat box, and particularly if time permits, I will absolutely get to them. And it looks like, I don't know exactly what time we're scheduled to end, but it looks like time will permit in this presentation. So keep that in mind. You have a resource right here, right now. I'm happy to talk. All right, with that, let's get back to some screen sharing. You should be seeing employment law, what we won't cover, which is almost everything. Not really almost everything, but there's a lot that we can't cover in this time frame. So I am going to talk about independent contractors. What I'm not going to talk about is volunteers, interns, and other non-employees. We're not going to talk about non-compete agreements. We're not going to talk about dealing with unions or employment laws that apply to businesses that contract with the government, or employee privacy laws, or the list goes on. So with that being said, let's talk about what we are going to cover. Number one, independent contractors. I told you I sneaked this back into the presentation. It's really, really important that you all understand that the government cares a lot about how you classify your workers. If you classify your workers as independent contractors and they are actually employees, guess who's going to come after you? The IRS, the Department of Labor, OSHA, the workers' comp people. There are all kinds of government agencies that will come for you if you get this wrong. So it's very important that you know what you're doing and make the right decision in the beginning. And why do you think people get this decision wrong so often? Because it's much cheaper and easier to have independent contractors than it is to have employees. So lots of times, starting businesses will classify all their workers as independent contractors, and they don't even know that they're taking this big risk. Okay? So keep in mind, think of a spectrum. We've got, at the one end of the spectrum, we have the checkout clerk at the grocery store. And at the other end of the spectrum, we have the plumber that you would call in order to fix a leaky pipe in your business bathroom. At the checkout clerk end of things is the person whose work you really control. That is the worker who you tell them when to come in, you tell them what to wear, you tell them how much you're going to pay them per hour, you tell them how to do their job, and you supervise their job. At the other end of the spectrum, you have your plumber. You call your plumber, you say, can you please come out? And the plumber might say yay or nay. But it's up to the plumber whether their workload allows them to come to you. They bring their own tools. They're transported there in their own vehicle. They have other customers and clients besides you. And so that is the true independent contractor. And most people, most workers fall somewhere in the middle. So you have to be careful to make sure if you are controlling every aspect of how someone does their job, they're probably your employee. If they have a lot of autonomy and they don't depend on you for all of their income, then they may be an independent contractor. I saw that we got a note. Let's see how good I am with the chat. Oh, we can go a good while. So we do have time to cover this independent contractor issue. This is really important. Whenever I give this presentation, I always get a question that I'm probably not going to get tonight because we're on a webinar. But the question is, well, it's okay because I file a 1099, so my people are independent contractors. The fact that you file a 1099 means that you've chosen to classify your people as independent contractors, but the IRS might disagree with you. The Department of Labor might disagree with you. The Workers' Compensation Board might disagree with you. And if they disagree with you, and they find out that you have classified people as independent contractors when they really should be employees, once again, that's when you get into trouble. It's really important to understand that up front. So that's the subject that I sneaked in for you all tonight. Now we're going to get to the other stuff that I had planned to cover. All right, let's talk about the Federal Fair Labor Standards Act. That's kind of a mouthful, but really if you think of this as wage and hour law, that's probably the easier way to remember it. The FLSA, or wage and hour laws that are applicable to you as an employer, say that you have to pay people minimum wage and overtime. So you pay at least minimum wage for all hours worked, and for any hours worked over 40, you pay 1.5 times an employee's regular rate. Note that certain categories of employees are exempt from the FLSA's minimum wage and overtime requirements. You may have heard of people who are exempt salaried employees. Those people, what that means is they are exempt from minimum wage and time and a half for overtime. They get their same salary every week, no matter if they work 20 hours or 60 hours, because they are exempt from the FLSA. Critically important that you get this right, not only because the DOL will come after you if you're not paying people correctly, the Department of Labor, but also because it is very profitable for plaintiffs' attorneys to sue you on behalf of whole classes of employees if you get this wrong. So I've litigated wage and hour class actions that settled. The claims were in the range of hundreds of millions, and they settled for millions of dollars. So keep that in mind. This can be really the reason we include the subjects we include in this presentation is because they are make or break subjects for your starting business. All right, so we said non-exempt employees have to be paid for all time worked. What if somebody stays over and works an extra hour after you had them scheduled? Do you have to pay them for that time? This is very clear. You pay employees for all non-exempt employees, your hourly employees get paid for all time worked, and they have to be paid at least minimum wage for that time worked. And furthermore, if that hour was overtime, you have to pay time and a half for that extra hour worked. So how do you deal with that? If somebody's showing up when you don't even want them to work, and then you have to pay them for that time? How does that fare? Well, the answer is you need to deal with it not by refusing to pay them, but by issuing discipline or potentially terminating their employment if they are coming in and working in contravention of your orders or directions. So consider exempt employees. There are not very many of these folks. These are going to be people who manage at least 2 other full-time individuals. So people who manage at least 2 other full-time individuals would be people who are exempt on the basis of their manager status. People like, for example, didn't mean to advance there. If you have an accountant on staff, that person would be subject to a professional exemption. But at the end of the day, if you're going to assert an exemption, you're going to put somebody on salary instead of paying them hourly for at least minimum wage for all time worked plus time and a half for overtime, then you are the person who will have to prove that that exemption was properly applied if it goes to court. So make sure you know what you're doing if you're going to classify somebody as a salaried exempt employee under the Federal Fair Labor Standards Act. By the way, Ohio has laws that essentially track federal law exactly on these subjects. So I reference the federal FLSA because that's typically the statute under which most lawsuits would be filed for this purpose. All right, so that's wage and hour law in a very, very small nutshell. Let's talk now about employment discrimination. The foundation of this is really simple. It is illegal to discriminate. Now, everybody on this call hopefully has heard that Ohio is an at-will employment state. And so whenever you hear at-will employment, what do people say? I can fire you for any reason and you can quit for any reason. It goes both ways, right? But there are exceptions to at-will employment. And one of those exceptions is you can't fire somebody for an illegal reason, like they refuse to be a drug mule for you, or they are African American, or they are disabled. Those would be illegal reasons to terminate someone's employment, even in an at-will state like Ohio. So when we talk about those protected classifications, what are they? We're talking about race, we're talking about sex. By the way, I didn't add this, but recently the US Supreme Court decided that not only can you not discriminate on the basis of sex, male or female, but you also can't discriminate on the basis of sexual orientation, and you can't discriminate on the basis of gender identity, so for transgendered individuals. So keep that in mind. Sex is a very, very broad category in this context. You can't discriminate based on age, national origin, ancestry, religion or creed, citizenship, and you might say, well, citizenship, if they don't have the right to work in the United States, then I should be able to refuse to employ them. That is absolutely right. But whether or not someone has the right to work in the United States is not necessarily tied to them being a citizen. So the important differentiator there is you can hire people who have the right to work, who have work authorization, work visa, or citizenship, but you can't require that someone be a US citizen in order to have a job with your organization. Other things, marital status, financial status, military status, arrest record, physical data. Why would arrest record be something that is considered discrimination? Because typically we find that people of color are so much more likely to get arrested and to have an arrest record that it essentially amounts to discrimination, because you're going to turn away so many more racial minorities if you require that any applicant not have an arrest record. So keep that in mind. Whether or not someone has children, whether or not that person has a plan for what they're going to do with their kids when they come into work, that cannot be a basis for hiring, firing, promotion decisions, etc. Workers' comp claim history, union membership, etc. So I'm telling you all that you cannot discriminate, and that sounds easy, right? I can't discriminate against people based on all of these classifications. At least you know how you're making your decisions. The problem is that the other people, the people that you employ, they don't have a window into your brain. So they have to look at the facts and circumstances in order to determine how they think you made your decision. And if they look at the facts and circumstances and they see that you fired, let's say I'm the employee, I see that you continue to employ 3 men who are late to work all the time, but you fired me for being tardy and I've only been late to work 3 times, then it's going to look to me like you fired me because I'm a woman, right? So it's very important that you apply your own policies consistently. And in that regard, your employee handbook is your best friend. As long as you follow it, your employee handbook tells you this is what we do. Someone violates a policy and maybe we follow progressive discipline, or we investigate it, we deal with it. We don't ignore it. Policy violations should not be ignored. Even if it's a person you happen to really like, an employee you happen to really like who's violating those policies, because next time it will be somebody you really don't like. And then you're going to be stuck applying those policies consistently. Meaning, if you didn't issue discipline last time for the male employee, you can't turn around and issue discipline this time for the female employee, even if you don't like her. All right. We talked about your exemptions from wage and hour law. Rely on those exemptions only after careful consideration, and never permit off the clock work. You should pay that time, and it should result in formal discipline every single time. Trying to think exactly what order. Okay, so we're in best practices now. Let's take a minute. Ask yourself, when you're thinking about issuing discipline, does the discipline create an opening for the employee to claim that they were treated differently on the basis of a protected status? Has the disciplinary approach been applied consistently to other employees? Are the expectations of this employee the same that I've had of all of my other employees? Have I tried to correct this employee's performance before jumping to termination? Is this employee going to be surprised by the termination? If an employee is going to be surprised by a termination, it means you've done something wrong. You have to have hard conversations, because that's how you protect yourself as a business and as a business owner. So if and when you do have to fire someone, make sure to try to use layers of decision making. Depending on how big your organization is, this may or may not be feasible. But Okay, so here we go. Layers of decision making. That may or may not be feasible. You know, if you are the only manager, you don't have another manager who needs to be consulted for all terminations. So that may be an issue. But if you do have the opportunity to have each termination decision reviewed by another manager, that's a best practice. And that other manager should be challenging that decision. What evidence do we have? What have we done with other employees who exhibited similar behavior? Really important, oops, I have this tendency to click on the text as I'm saying it, and I keep jumping ahead on the slide. Sorry about that. You should avoid forcing an employee to resign. Generally, if you force an employee to resign, they are going to come back. It's not going to save you from a wrongful termination claim. They're just going to come back and claim that they didn't have a choice, and it's going to make them really busy, really angry with you. Avoid, failing to offer constructive counseling until it's too late. Have those hard conversations. And this is one I get all the time. Yes, I want to fire this person because they damaged a customer's order. And I think that was careless and it cost me money and I want to fire them. And I say, okay, have any of your other employees ever damaged a customer's order, for example? And they say, well, yeah, I mean, basically all of my employees have done that at one time or another, but I don't like this person. I've been waiting for them to mess up so I can get rid of them. And if the issue is that you don't like this person, think about a lawful reason why you don't like that person. Is it because their customer service demeanor is not good and they've not shown improvement in that area? Is it because their work is generally sloppy? In all of those circumstances, you have to be honest about the reason, and hopefully if you're being honest and having those hard conversations, then a person knows, you know what, I'm on thin ice at work and it's because of XYZ performance reasons. Their termination doesn't come as a bolt out of the blue and a total shock. Because if somebody is shocked by their termination, they think they've been doing a great job, and then you suddenly terminate them, they're going to go around looking for the real reason they were fired. And oftentimes they're going to come back and say, well, it's not because I was a poor performer because nobody ever told me I was doing a bad job. It must be because I am Asian, or I am a pregnant woman, or I'm transgender, or whatever the case may be. So keep that in mind. It's important to have the tough conversations. All right, with that, I'm going to open up to the chat for questions. And I also wanted to, I'll bring up the handouts. Let me just open those up. I'm gonna stop sharing for just a moment while folks type in questions. And we'll talk through the handouts briefly since we have time. This is a very different, normally I give this presentation and just the, do I have to open up the chat to the group, Randy? I'm hopeful that technology.
Actually, they can chat already. Okay. If you want, we can unmute the microphones for a couple minutes here.
Yeah, let's do that. That's even better.
All right. And so, oops. So you all have access to speak up. Anyone has any questions?
Okay, hi Meredith. This is Earlene Wallace. I have a question.
Hi, Earlene.
Hi, I wanted to know, I have a transportation company and I am an ex-cab driver. So if I get overwhelmed and I get a request for transportation, I rely on some of my ex-cab driver friends to bring their van and maybe, you know, trail along. If I use them regularly, should I be putting them in as like a employee? They don't rely on me. They have their own businesses, but I use the same ones over and over because they're reliable. So should I think about putting them on staff as employees, or is it okay for them to be independent contractors because I call on them when I need them?
This is a great example to conduct our analysis. So let's think about that spectrum. Do these individuals own their own vehicles?
Yes, they do. And
that's what they're driving when they drive for you?
Yes.
And Are you paying them for time worked, or are you paying them a percentage of their total fare?
I usually split it depending on like how the load is. If there's 4 vans and they're one of the vans, then I'll give them 1/4 of whatever we take.
Okay, so they're sharing in your profits.
Yes.
And these are folks who they otherwise operate as a driver independent of their work for you.
Yes.
And do you require them to wear a uniform?
No.
Okay. And so this is all sounding more and more like independent contractors, even though you may be using them fairly frequently, as long, there's going to come a point where you cross over that threshold, right? Where our balances, the
Mhm.
scales tip. But it sounds like right now, the way that you have this relationship structured, you are probably okay.
Okay. I just wanted to check that. Thank you.
Now, by contrast, just for the benefit of the group on the call, if you were telling them what they wore, if they were driving your vehicles, if you were telling them, when to come in every week and paying them an hourly wage, that would all weigh in favor of these people being employees rather than independent contractors.
Okay. Thank you.
Yeah. Any other questions? That independent contractor subject is always the one where people are like, oh, let's talk it through. So feel free
Yeah,
to, even though we've answered one of those.
We have trainers. This is Angie from Angels in the Infield. And we have trainers that come in, and if I can't make it to a training session, they come in and do it. And we just pay them for their time spent with that customer. We do have t-shirts that they can wear, but if they're not wearing them, it's no big deal. Everybody understands that they're a fill-in. So are those still independent contractors, or are those employees?
These folks in some ways are a little closer to the middle of the spectrum because you are paying them an hourly rate rather than sharing in the profits for this job. And because of you offer the t-shirts, presumably they're coming to your place of business in order to conduct the training.
Yeah, we also do training in the customer's house too, though. So they might be driving there in their car.
Yeah, so how they're getting there, are they showing up with equipment? And if so, is it your training equipment?
No, it's always theirs.
So those are all things that would weigh in favor of those people being independent contractors. Keep an eye on it though. The IRS has, I think it's 10 different questions, or it might even be more than that. It might be like 20 or 30 questions that digs into, their test is sort of the default test that really digs into in what ways are you exerting control over these people and where do they fall on the spectrum. And so I would take a look at the IRS, let's see, I'm just going to Google it real quick so I can tell you, IRS independent contractor test. Google is already filling it in for me, but I suspect that's because of what I do for a living. I've probably asked Google this question before. Right. But yeah, IRS has all kinds of like small business and self-employed resources. And so they do have versions of this test that are in plain English so that you're not trying to decipher legalese. I was going to see if I could figure out how many factors it is, but I think that might take me too long while we're here on the presentation. But in any case, it's readily accessible on their website.
Thank you.
So sometimes a question that I get, and until I hear somebody, feel free to interrupt me. You could wind me up and I could talk for hours. But a question that I frequently get when I'm talking to entrepreneurs is, do I need to have an employee handbook if you do have employees? And the answer is there's no law that says you have to have an employee handbook. There are laws that say you have to have certain posters in your workplace, right? The EEO is the law kind of poster, the workers' comp poster, the minimum wage poster. But there's no law that says you have to have an employee handbook. But you know that a lot of employers do have employee handbooks. So the question becomes, why is that? And the truth is, you know, I alluded to this briefly in our best practices section. Your employee handbook can act as an incredible guide, especially if it's an employee handbook that was drafted by people who understand HR and HR laws. You can understand your obligations under those laws by referencing and following your employee handbook. So for example, a lot of people might not know that if someone decides to volunteer as a poll worker at an election, that person, that's usually coming from my microphone. I have dogs in addition to the cats. So what we were saying is that if a lot of people don't know that if someone volunteers as a poll worker at an election, that time they automatically get that time off and they can't be disciplined for that time as long as they give you enough notice. Now that may be inconvenient, but if you know that, then at least you know to comply with that and figure out other coverage arrangements. If instead you didn't know that and you were like, you come in or I'm going to give you written discipline or I'm going to fire you, then potentially you are violating the law. But if you had an employee handbook and you followed that employee handbook, you would have known better. So those are the kinds of things that can be really helpful if you have an employee handbook just to help guide you along the way. I'm still open to other questions though.
I do have a question, Meredith. So for example, we've been talking about and we've been receiving questions about, you know, employees versus subcontractors. Worst case scenario for categorizing or naming someone as a subcontractor and in fact they are an employee. What is the worst case scenario?
The worst case scenario. So you let's say you did this wrong for 5 years. You had someone categorized as an independent contractor and you find out, oh my gosh, I did that wrong. They were actually an employee. Worst case scenario is probably that person sues you and they sue you under something like a non-discrimination law or a workers' comp law. And it turns out that you are liable and you haven't been paying into workers' comp. Okay, so that's number one. Another really bad thing that could happen is the IRS discovers this and they say that you owe back employment taxes for the last 5 years on this individual. So whatever money you have saved up front, you now owe all at once and you've got to deal with the IRS on that subject. The Department of Labor could also discover this and try to enforce things like minimum wage and overtime rules. So let's just say let's use the example of our drivers. Let's just say when you totaled out the amount of money people were making per hour, sometimes that number would come to less than minimum wage, or sometimes they would work more than 40 hours in a week and they wouldn't be paid time and a half. You're going to have to go back and pay the difference. And then you're also going to have to pay that difference times 3 because we have what are called liquidated damages under the Federal Fair Labor Standards Act. It's another reason that the plaintiff's attorneys love to file those lawsuits so very much. So worst case scenario is exactly what I talked about. I had the lawsuit where it was hundreds of millions of dollars. Now that was a big staff. You all are not going to be facing hundreds of millions of dollars worth of damages, but you could very, very easily be facing hundreds of thousands or even $1 million worth of damages in the event of a lawsuit or an IRS audit that didn't go your way.
Yeah. So bottom line, it can be very costly.
It's so worth it to do that analysis up front. And if you find like, we're really on the cusp, think about, are there ways that I'm controlling these people that I don't have to? And if you can loosen the reins a little bit in order to shore up the independent contractor classification, you should absolutely do so. Right? So let's just say, Angela, that you were making people wear your t-shirts. Maybe we decide that a dress code is a little bit too far. Maybe we're just going to go with, we take that requirement off the table. Another thing, we talked about employee handbooks. Do not give your independent contractors copies of an employee handbook and expect them to follow it, because you're going to be treating them like employees in that circumstance. And what happens when you treat a worker like an employee? They become an employee. So that is a really important point to keep in mind. If you want someone to continue to be an independent contractor, don't take actions that would indicate otherwise.
Awesome. Any other questions, guys?
Anything people are struggling with right now, struggling to get set up as employers, struggling with all this COVID leave, that is a whole other thing.
Mm-hmm. Well, I have one with contracts pertaining. I mean, I can go for days because with so many clients that we see, there's always a legal question. So going back to setting up a business initially, or, you know, bringing in partners at some point. When it comes down to family members specifically, let's say it may be a partner, it may be a husband, wife, it may be a brother, sister, a relative, whatever it may be. Should you go into it without a contract because they are family?
Yeah, it's just family, right? It's a family-owned business. It's fine. It's all the same family. It's the same pool of money, right? Except that, let's think about some of the most acrimonious relationships. It's when family relationships go wrong. So imagine being in a situation where, you know, your spouse or partner with whom you're going into business, that relationship ends, and maybe it ends under horrible circumstances, unimaginable circumstances. You don't write a contract because we're happy now. We write a contract because we want to deal with what happens if we're not happy in the future. So I think that's a great question, Randy, and the answer, and yes, I am a lawyer giving you this answer, but it does not change the fact that a contract is still a really good and a really important idea, and also required under Ohio law for a lot of things like establishing an LLC and certain business entities under Ohio law can be absolutely necessary to establish who has rights and what those rights are. I thought you were going to ask me details of like how to set up an LLC and I don't know those things. So
we can help you with that, but so we can help with establishing the businesses, but when it comes to creating your agreements, your business agreements, we do not touch that, right? We always suggest to work with a lawyer, but time in and time out, it's just consistently coming through our office. We have, you know, a couple or a team or family members like, hey, we're gonna put this together. And I'm like, have you guys talked about terms? Have you guys talked about maybe percentages? Have you guys talked about maybe what the responsibilities are? Have you guys talked about what happens if someone wants to leave the business? And it's like they've never thought about it. And that's a huge issue because we're talking about a business that may go from 0 to $1 million, you know, maybe overnight, maybe over a course of 5-10 years, but money can change people, and sometimes for the best, sometimes for the worst. And so I always strongly suggest, it doesn't matter who the person is, whether they're family or not, get a contract so that you reduce your stress levels later, so that you reduce headaches long-term. And if someone starts to think differently, then that document, you can say, hey, do you remember this document we signed? Why are you doing something different from here? Right. And so I mean, I can't stress enough the importance of having a written contract between you and anyone else who's going to be part of this business.
I'm just going to second that thought. I have nothing to add to it. It's spot on.
Guys, anyone else has any other questions? I mean, I can go for days here, but I want to give you guys the opportunity to ask your questions now. Well, in that case, I'll give you one last question, and then we'll go into your documents, which I emailed everyone. You probably don't have access to it now, but it's in your email, I promise. Here's another one that I get all the time is, can you hire a minor? And the second question to that, second tier to that is relative minor and a non-relative minor. Okay.
So can you hire a minor? Yes. Depending on the person's age in Ohio, they may need to have a work permit. And I don't address this question that frequently, so I can't remember if the age is 14 or 16. Maybe at 16 and older, they don't need a work permit, and under 16 they do, and under 14 you cannot employ them. But in terms of a relative, if the relative is your kid and you are just having them, you know, bus tables or something 4 hours in the evening during the dinner rush, then the answer is, yeah, you can have your kid do work for you if it's an immediate family member. If we're talking about, you know, your cousin's niece, that's a whole other question. And you really want to be extremely careful about following employment laws with respect to minors, even more careful than you are about following employment laws with respect to adults, because those laws are not written in your favor and they can be very complicated. So yes, you can employ a minor. There are some regulations and some requirements that are applicable. And if you do employ a minor, then you want to make sure to follow those regulations very closely. I think the state of Ohio is the resource to get you that information.
Awesome. Thank you, Meredith.
Yeah, Randy, what's the name of that? There's a state of Ohio like small business resource that folks can reach out to get answers on those kinds of compliance questions, so they don't have to hire a lawyer every time they have that question. Do you know who that is?
There is a few resources that I can think of off the top of my head. I don't know which one is the silver bullet, but we can reach out directly to the Secretary of State, of course. We can reach out to like SCORE. We can reach out to the SBA specifically. There's a slew of resources that we can definitely reach out to. So if anyone has any questions or needs more information, feel free to reach out, and we'll make sure to send you in the right way.
Keep that in mind, because I don't want people like, yes, I'm a lawyer, but I'm not here to tell you that every single issue you have, you need to call your lawyer about. Frankly, I'd probably find the answer to that question the same way you would if I had that question. So don't doubt yourself. You know, if you do the research and you do your homework, then some of these types of compliance questions you can answer for yourselves. All right, I'm going to just briefly share the content that is coming to you as handouts. Let me switch screens on this so that you can see it a little better. Okay. This is probably still a little small on your screen. It'll be a full 8.5 by 11 page when you get it. But these are the kinds of questions that I actually ask myself before I go into negotiations. And this is like everything from, like I just recently bought a car a few months ago. And I walked in asking, why am I entering this contract? What am I going in there looking for? Who is going to be involved in this agreement? I think it's going to be myself, maybe a financing entity, and probably the dealership if I end up buying this from the dealership. How long will the contract last? I knew going in that I wanted to arrange financing over a 3-year period instead of a 5-year period. And what do I want? I went in knowing exactly what kind of car I wanted to get and exactly what I was going to be willing to pay because I had done my research. What is the appropriate amount? And then I knew, you know, when, over what period of time will I need to pay this off? How much will I have up front to put as a down payment? And is there, you know, do I want to, this question on here is, should any of the promises be performed in a certain way? One of the things that I did some research on was, am I going to require that a service contract be included with the sale of the car? Is that even something that dealerships do? And if so, can I get them to throw that in? Do I need or want insurance relative to this? Well, I already had my own car insurance, but I did a little bit of research to find out how that insurance might change when I got my new car. And were there any applicable contract laws in the state of Ohio? I frankly have no idea because I didn't research that piece. But I had already bought cars in the past, so I had a pretty good idea of what the transaction was going to look like from a legal perspective. So even if you don't write this out, and I do recommend that you write this out, but think about in advance what am I looking at? What subjects do I want to address? Because if you write them all out in advance, you're not going to forget any of them when the time comes to actually negotiate. Negotiations can be intimidating, they can be nerve-wracking. Even if you're not intimidated or nerve-wracked, sometimes you just forget stuff. And so it's really good to go in with a clear checklist of what you're trying to achieve when you walk through that door, to negotiate with a landlord or to negotiate with the car dealership or whoever you're dealing with. So this is something that use it as a worksheet, or at the very least use it as food for thought about how you're going to approach contract negotiations in the future. Let me switch over here. The other document that I'm sharing with you today, let's just pull it up rather than talking about it in the abstract. This is really important. Can you guys, wait, let me. So you should be seeing something that says protected classifications and basic non-discrimination tips. And what I have done here is I just really want you to see a list somewhere, have a list of the reasons why you can't hire, fire, make compensation decisions, make promotion decisions. It's just that some of these are not that obvious, like arrest record we already talked about. Children or family status. You know, it's really common and really tempting to ask, oh, so you have 11 children. Do you have a plan for what's going to happen to them when you come into work each day? Don't do it. Don't do it. It's not up to you to make that determination in advance. It's up to the employee to either show up and show up on time or not show up and not show up on time. So don't try to take that into consideration. And keep in mind too, this list is not comprehensive. There are other reasons why you can't make employment decisions that would be considered discrimination, but these are the most common, the most obvious ones. One that I mentioned that's not on here, you'll recall, is sexual orientation and gender identity. That's a pretty new, within the last month or so, that decision came down from the Supreme Court. Don't ask about these things during an interview. Even if you're not going to make the decision based on these things, don't ask about them in an interview, because if you're not going to make the decision based on these things, then why would you ask about them in an interview? You can only get yourself into trouble that way. And then of course, you know, we talked about, this is just some of the pointers that we've already talked through, but I wanted you to have this summary on hand in the event you needed to reference it down the road, just to give yourself a little flag for things to keep an eye out for. And with that, I don't have any more specific content for today. I'm happy to take a couple of final questions, or we can call it if you guys are ready to call it.
All right, guys, this is your chance. You have the legal counsel right in front of you. Take advantage of this moment.
Free lawyer.
Any questions or experiences that you may want to share concerning this topic specifically? Pretty quiet group today.
If you find you have any, you know, feel free to reach out, Randy.
Great.
You know I'm there.
I think you hit this before, but I want to make sure we touch this specifically. In the case or in the event that you have an employee who is non-compliant, and things may be laid out in an employee handbook, but let's say we have employee A, and employee A, you know, has been coming late, it's not fulfilling their duties, maybe doing something probably on the phone too much, and you're trying to, you know, get these people to work and say, hey, this is the protocol, this is what we're expecting from you. When you know that it's your time to let this person go, should you or should you not have good documentation? Is it against the law to fire someone on the spot without giving them prior warnings? These are questions we get all the time. So what would be your top recommendation?
Okay. So number one, it is okay to fire someone for any reason as long as it's not an illegal reason. Number two, you are probably going to get accused of discrimination of some kind in the event that you fire somebody out of the blue, because that person's going to be looking for the reason. Why on earth did they fire me? It must be because I'm a woman. It must be because I have 11 children. It must be for any number of these unlawful reasons, right? So the reason that you want good documentation is not because the law requires that you document performance issues. It's because you're going to lose at your lawsuit if you don't have any evidence that this person was a bad employee. And what does evidence that this person was a bad employee look like? It looks like performance management coaching. It looks like written prior discipline. It looks like record keeping related to this person's frequent tardiness. If you are finding somebody on their phone, don't say, hey, put your phone away, I've told you before. Write it up. And don't write it up because you're a bureaucrat. Write it up because you want to protect yourself and your business. So the answer is yes. Technically, you can fire somebody at any time for any reason, but none of my clients do that because they don't want to get sued. And if they do get sued, they want to be able to defend themselves. How was that, Randy?
That's awesome.
I saw we got a question about paying into unemployment and workers' comp for all employees. I believe the answer to that question is yes. If they are your employee, you have to pay into unemployment and workers' comp.
Correct. It's law. If you have one employee, you have to pay into workers' comp.
That's exactly right.
There's no way around it. The only way that you can do without this would be subcontractors, and you're by yourself. That is the only way you can go around the rule.
Right. And that's why people like to have independent contractors, because you don't have to pay into unemployment and workers' comp. You don't have to pay employment taxes. The problem is if you get that wrong, of course, there's the other side of the coin. You might end up paying it all back and more for having made a mistake up front.
Okay, one final question from me. I think I'm the one who's asking all the questions.
You get all the questions from your client.
This is true. So we already talked about, firing someone or letting them go. This, believe it or not, has been on my table or on my desk previously. Should you disclose the reason why you let them go? And if you don't disclose why you let them go, is there any issues with that?
I actually get this question a fair bit from my clients who don't have like a robust HR function in their organization. I'm litigating a case right now where my client refused to state in the termination letter the reason for the termination. And guess what? Now I'm litigating this case. The person claims that the reason for their termination was really because they took federal Family Medical Leave Act leave, protected leave, and because they were a woman. And if I just had a termination letter that said, we fired you because you moved to Denver and informed us that you were going to do your job remotely without getting our permission first, then my case would be so much easier to defend. So as long as the reason for the termination is a lawful reason, it's only going to help you to put that in writing. Now, if you're terminating someone because they are Korean or Russian and you don't like to, obviously that's an unlawful reason. It's not helpful to me if you put that in writing, but hopefully you're not terminating someone for that reason to begin with.
That's awesome. So guys, you guys are getting firsthand experience of what is going on at this current moment. So this is an actual case, actual litigation. So we'll give one more second here. Anyone has any questions pertaining to this subject? I know that some of you may not feel comfortable with asking questions in this platform or in this forum, and that is completely okay. What I do ask is that if you're not comfortable, feel free to reach out directly to me. You can call me, you can email me, you can hit me up through Facebook, or you can probably shoot an email over to Meredith, and we'll help you. And just remember, we are here, we are sold out for you. We want you to be successful. We want you to grow. We want your business to grow. And the lifeline of this country is small businesses. So you are extremely important. Your business is extremely important to not just the local economy, but just nationally. So we are invested in your success. And so we're going to go up to bat with you. And whatever resource we have at our disposal, it is completely yours. And we will make sure that we can link you up to whatever that resource may be. So if you don't feel comfortable, that is completely okay. We still do want to answer your question if you have it though. So feel free to reach out to us in that event.
Oh, I see we got one more.
Okay.
This is a pretty quick answer. So the question is, I've got these protected categories, and one of them is physical data. And typically, why would it be unlawful to discriminate on the basis of physical data? Well, the reason is because often physical data corresponds with certain disabilities. So for example, if you refuse to hire someone because they walk with a cane or because they are obese, for example, that physical status may correspond with a disability, and therefore discrimination on that basis would be unlawful under the Americans with Disabilities Act of 1990.
That's great.
Okay. Thanks,
right.
everybody. I'm a resource. I'm here for free, so I'm here because I love doing this and because I love what you all do. So I'll echo Randy's sentiment. Feel free to keep those questions coming.
Thank you so much, Meredith. While I'm closing this out, please feel free to chime in if anyone has a question. We still have some time here. These last sessions, we've gone up to the mark at 7:30, so we are a tad early today, but that's okay. I think it was a lot of information. I think it was great information. If we have not attacked what you are looking specifically for, this is your moment to ask so that we can attack that. On one of our previous sessions, we talked about like lease contracts, and we talked about what are you liable for, what if there's any personal guarantees and whatnot. Those are other things that we can talk about on a one-on-one basis as well, because it can get very deep, and it really has to do, it's a contract for contract. There is, and Meredith, please correct me if I'm wrong, there is no one standard contract. Contracts come in all shapes and sizes. Some of them are ridiculous because I've seen some that is just, I just can't even believe what's actually written. So you have to make sure you understand what is written. Make sure that you can stand by and guarantee whatever is asked, to be guaranteed. And when you are not sure, find someone to help you out. Make sure you understand. I've seen too many people hit borderline or even hit bankruptcy because they had no idea what they were getting into. And I'm not doing this as a scare tactic. I'm not doing this so that you get away from contracts. It's just the more information you have, the better answers you're going to get, the better outcomes you're going to get, right? So you need to make sure you understand the process, make sure what the documentation indicates, so that in the case that you get sued, we hope to God it doesn't happen, you have a backbone to fight with, and we make sure that we have the upper hand. Okay. So other than that, you guys already received an email from me. It includes the documents that Meredith just shared with us on screen. It also has the link to our jot form, which will have the 10 questions for today's session specifically. I promise you, we've touched every single one of them. All the answers have been given in this hour and about an hour and a half. All the answers are in there. Remember that you have to answer these questions in order to finish the whole program successfully. Also, to remind you all, I think there's 2 or 3 of you in this session that are interested in Tienditas specifically. I think I have 2 appointments with 2 of you already to follow up on Tienditas, which is our business incubator. I will be following up with you guys. We'll have one-on-ones on that. But if anyone else is still interested in having or applying or putting in your proposal for Tienditas, you are still welcome to put that proposal in, right? We can still have sessions and figure out what is it that you want to do. Remember, it's an incubator, so the terms are very friendly. The rent is extremely friendly, and it's a 1-year term contract. So if you have any other questions, any other concerns with that specifically, reach out to me, send me an email. As I said in the last couple sessions, if I have not responded in 4 hours, resend that email to me. Emails have been nonstop since COVID took over our lives. My email has been bombarded on a daily basis, including weekends. So if I have not responded in 4 hours, shoot me another email again, please, I beg you. So other than that, thank you all so much for your time. We are about 35 minutes ahead of schedule here. We will meet again on Wednesday for our last session, which will be marketing with our advisor, Cole Worley. Publicly, once again, Meredith, thank you so much for being such a great partner, a reliable partner that we can always count on, always answering those, fast questions, those last minute questions, and just being so accessible. We greatly appreciate it because it's not the same all over the city. So we greatly appreciate your partnership. And so we will obviously keep this going for quite some time, and feel free to reach out to us if you need anything. Okay.
Fantastic. Thanks all. Good to see you. Good to meet you.
All right. Thank you so much. All right, everyone. You guys have a good night. We will see each other on Wednesday, same time and same channel. Take care.